First matter on this afternoon's calendar is Williams v. Beemiller. Counsel?
May it please the court, my name is Jonathan Lowy with Brady. I'm here with Jim Grable of Connors LLP on behalf of plaintiffs' appellants Daniel and Eddie Williams. May I reserve 3 minutes for rebuttal?
3, sir?
3, yes.
You may.
Thank you, Your Honors. This case can be decided on one piece of evidence from page 458 of the record. That is where Defendant Brown testifies under oath that before he sold the .85 handgun purchase, which included the gun used to shoot Daniel Williams, he's explaining to federal law enforcement his understanding of what would happen with those guns were he to choose to sell them. And what he said is Upshaw, who was the buyer, was going into business. They planned on opening a store in Ohio, one in Buffalo. They planned on opening a store in Ohio, one in Buffalo. That was before Defendant Brown made this sale. So that is testimony of him actually considering, in personal jurisdiction terms, whether to purposefully avail himself of the New York market, and he decided to. He didn't have to. And in fact, another gun dealer chose not to.
So is that an expectation or speculation? Is that what you're...
It's far more than that, Your Honor. I mean, this is a plan. This is every bit as firm, particularly on summary judgment, as if this were a sale to a legal distributor who also would have a plan to distribute, that is, resell the guns in the New York market.
It's a plan without a license to do that and without a store or even a location. So isn't it somewhat inchoate?
Well, Your Honor, that goes to the fact that, in fact, this was a gun trafficker. It was an illegal reseller. And that, if anything, helps our case, not hurts it. New York's authority to exert jurisdiction over Brown should not be diminished because Brown chose to deal with someone who was quite obviously an illegal trafficker rather than a legal one.
Well, except that you're sort of saying that Brown knew that what he was being told was a lie, in which case, how can we rely on it for the guns going to New York?
On summary judgment, Your Honor, of course, the court must look at the record from the best standpoint for the plaintiff. Court cannot weigh credibility in the court.
So from that standpoint, one way, how I think you see, what I understand you arguing is that Brown knew, this is in the light most favorable to the plaintiffs, Brown knew that some or all of these guns might someday find their way into the state of New York, right?
Much stronger than that, Your Honor. I mean, this isn't might one day. This is not someone who is saying, I'm buying 180 Saturday night specials for my personal use, and one day, maybe when I retire, I'm going to resell them. Brown knew from the outset, from his own testimony, that these sellers were buying inventory. The only reason they were buying these were to resell.
But they didn't know that would ever come to fruition, that store in Buffalo. In fact, as far as we know, it never did come to fruition. So what he's selling to an Ohio resident, right, who says, they have a long conversation, as I understand it, that about opening up a gun shop in Ohio. And then it's sort of an afterthought that he says, and I'm originally from Buffalo, and I might like to open up a store there too. But when he's selling these guns, he doesn't know if they're going to stay in Bostic's basement in Ohio forever, or until he opens a store in Ohio, or maybe someday he'll open a store in Buffalo. I don't see how that is anything more than speculation.
A couple things, Your Honor. One is Brown's testimony is inconsistent. He does not have his story straight. And actually, if in 2005, when he was deposed, when he is always mentioning Buffalo as where the guns could be sold. It's not until 2014, the deposition, when personal jurisdiction is at issue, when he begins saying, oh, now I remember 14 years later that the guns were only going to be sold in Ohio. And Your Honor, the court cannot pick and choose which statement of Brown's to believe. That's why the statement on 458 of the record must be accepted. You could ignore all the other statements.
No, you can't take it out of context. You don't have to accept every word. You have to, you look at all of the evidence and you view it in the light most favorable to the plaintiff.
Well, and more importantly, his own words is people plan a lot of things that never come to fruition.
But, Your Honor, this was a concrete plan to reject personal jurisdiction on due process grounds on this record. I think the court would have to say you need a stronger...
To even get to due process, don't you have to first go through the statute and figure out if it satisfies the statute? I mean, I think at the appellate division, there was level anyway. Originally, there was a lot of discussion about whether even the statute in your appellate division briefs was satisfied.
The appellate division found that there was jurisdiction under New York law, and that issue is not appealed. So the only issue before the court is whether there's due process.
Where do you fit under the statute?
Well, again, that's not an issue on appeal, but we fit under both, as the trial court found, both under 302A,
So when you
3,
say,
1, and 2, both of them.
when you say it's not on appeal, how do you even engage in the due process argument if the statute isn't satisfied?
Well, the statute was satisfied. The appellate court, the trial court, and the appellate division both found it was satisfied. Brown chose not to appeal that decision. Therefore, the only issue before this court is whether exercising New York jurisdiction in this case is contrary to due process. And I would say that to find that on summary judgment, the statement that...
It's discussed in your briefs here on both sides, whether the statute...
It is, for context, because I think it's important for context, but it is not, and Brown says in their brief, they did not raise the issue in appeal. So it's simply,
Let's
is not
assume
a
it was
question for
before us, counsel. Under the statute, 302A31, where we say, or derives substantial revenue from goods used or consumed in our state, what is the standard for determining derives substantial revenue?
receives substantial revenue. And Brown received revenue of over a third of his sales in 2000 were of products used,
What if his
used in New
total
York.
sales were $10, so a third of his sales was $3.33? Is that substantial revenue?
That would be a different case. Maybe it would. I mean, our case, we have 180 guns and
That's an
$15,000.
interesting question. First, on Romanet 1, I thought the appellate division, you can correct me if I remember wrong, ruled in your favor on Romanet 1. Is that correct?
That's correct.
All right. So they determined, as a matter of fact, that there was substantial revenue derived here, right?
Yes.
All right. So taking it to the next step, Judge Stein raises an interesting point. Obviously, one gun would not establish minimum contacts, and 10,000 guns would establish anyone's perception of minimum contacts. You'd agree with that? Let's say he sold 10,000 guns to Mr. Bostic, and those guns were eventually transported to New York. It'd be really hard to argue that it wasn't, right?
Yes.
So our question for us is, what constitutes minimum? Isn't that really what we're down to here?
Well, I don't, Your
Because
Honor,
you seem to
because-
have some facts in your favor as to minimum. You have the 45-minute conversation that he had. You have the 181 guns. You have the 35% of his 2,000 revenue, or his 2,000 sales went to Mr. Bostic and went to the city of Buffalo. And then you have 15,000 in total revenue. So those factors all seem to weigh in your favor. It's not just the conversation. Isn't there more in the record?
That's absolutely correct, Your Honor. And the due process question for minimum contacts is,
So
did Brown
is there
purposely avail
any case
himself?
law? Is there any New York case anywhere that says, that where there's a factual situation that says that 35% of your revenue is not enough for minimum due process, that 20% isn't enough for minimum due process, minimum contacts for due process?
Well, just the opposite. I mean, there's Lamarca, I believe it was 2.8% of revenue of that Texas company was from New York, and there was jurisdiction under the statute, and it comported with due process.
So
and that, by the way,
let's assume then that the sales themselves are sufficient. Then we're really down to the question that you initially started with, which is whether or not the record is sufficient for you to argue that he purposely availed himself of jurisdiction. Aren't we back to that?
Exactly, Your Honor, yes.
And it's really an interpretation, a factual determination as to whether or not his remarks constitute purposeful availment. And then we get into the standard of what applies in summary judgment.
That's correct. And what you need is foreknowledge and then acting on that, voluntarily acting on that. And Brown was told of the plan, and then he acted on it.
One of the difficulties in the case is in the way the appellate division analyzed it, they looked at the Walden D. Fiore case, Walden versus D. Fiore case, and the facts there seem to be substantially different than what we have there. It's pretty clear there was no contact there, and I'd have to agree with Judge Thomas in the determination. Is there other federal jurisprudence that would support your version of applying minimum contacts here? Because the appellate division pretty much relied on Walden alone. So I'm thinking about, they had a CF cite there to the Burger King case. You're familiar with that?
Yes, Your Honor, and Burger King, I think, has very favorable language. I mean,
like what?
For one, Burger King says that due process may not be wielded as a territorial shield to avoid interstate obligations that have been voluntarily assumed. I may have missed a word or two, but that's the gist of it. Voluntarily assumed. That gets at what purposeful availment is, the choice Brown had.
It has some
do I
language
supply New
before
York or
there where it talks about purposefully derived benefit from their interstate activities an individual must in order to establish jurisdiction. So once again, we're back. And it seems to me this case really narrows down to the question of purposeful availment, not the amount of sales, not the revenues, but fundamentally purposeful availment and whether or not there's record support for that argument.
Your time has expired, counsel, but I know that Judge Garcia has a question for you.
Thank you, Chief Judge. I would like to go back actually to 302 A3 Romanet 1. And the issue I'm having with the appellate division is they seem to have counted all of the revenue from guns that wound up in New York State. And I don't see that as being consistent as the way courts have applied. Not arguing that those guns were sold in New York, but the way we've applied that Romanet 1, it's a lesser doing business type test, and we've always looked to some type of volition. So again, you have to kind of take this hook of maybe he was going to open a store, or he was going to open a store in Buffalo and in Ohio, but it's not the type of I'm selling it to a distributor who's distributing in New York, and it almost was assuming the sales and then assuming jurisdiction, and I can't find a case where any court has applied Romanet 1 in that way. Well, without this kind of volitional element. It's like a bike store in a local town, somebody comes by, buys a lot of bicycles, winds up selling them in New Jersey, or vice versa. That person had no idea. I'm a local store. I sell to local customers. The person had New York plates, but they wind up selling these bikes in New York. Can they get hauled into court under Romanet 1 for that? If they're used in New York?
The language of the statute is used, and Your Honor, this should be no different than if Bostick and Upshaw were actually legal gun dealers in Buffalo going to Ohio saying, I want to buy guns to stock my store. The only difference is these were criminal gun traffickers, and that increases New York's interest, does not diminish it.
Putting aside they're criminal gun dealers. Let's just look at what happened here. And I think we've gone, and I've read that page of the transcript in 458, and it says Buffalo and Ohio. But, you know, it's again, I'm planning to do this, I may do this. He's selling these guns in Ohio to an Ohio person. And yes, they assume for this purposes they wind up in Buffalo. But that, I mean, in order to interpret it as they just show up there, I think that would be a reading of Romanet 1 that would cause significant due process problems.
Your Honor, I think that the facts are analogous to Lamarca, where you had a Texas corporation with a factory in Virginia that said, New York should not have jurisdiction over me because I sold goods in Virginia to a distributor who then resold in New York.
But they knew it was a New York distributor.
They knew every bit. The word planned, Your Honor, to find that the word planned is not sufficient.
But it's not even I'm planning to sell them. It's I'm planning to open a store. He doesn't have a license to do that. So you're believing, in one sense, you're asking us to believe, oh, he understood that this criminal was going to open a legal store in Buffalo. But he's also saying he's going to do that in Ohio, which would seem to me a lot easier proposition. So it's not, I'm selling to a distributor who's distributing in New York. It's I'm selling to somebody who told me I'm planning to open a store at best. I'm planning to open a store in Ohio and New York.
Well, the plan to open the store in New York and Ohio was completely tied to the reason why they're buying the guns. Those weren't independent. The only reason these people were buying guns was in order to resell them. And the fact that it was, whether it was legal or illegal,
is there any proof in the record, you say that, is there any proof in the record that shows what happened to these guns after they went to Buffalo?
Yes, the record is that
besides this incident itself.
every single one of them, the record, and it's in Bostic's criminal papers, which are part of the record, that every single one of these guns was used in New York. Bostic brought every single one of them and sold them on the criminal market in Buffalo. So they were 100%, all 182 of them, used, that is, consumed in New York.
Thank you, Mr. Lowy. You'll have your rebuttal time,
Thank
sir.
you.
Counsel?
Thank you, Chief.
Welcome.
Good afternoon, Your Honors. Scott Brom on behalf of the respondent, Charles Brown. One thing I'd like to start out with is, Your Honor, based on the conversation you were just having with respect to what the appellate court actually did below. And it's kind of interesting the way they went through that long-arm analysis, then they got to minimum contacts and federal due process, and then they circled back up with long-arm. And so, as Your Honors know, under 302A3, the first thing that you have to do is get through the 302A3 language. Then you have to meet either I or II.
So it's your position that we have to get through 3002, the long-arm statute, before we get to the due process question?
Yes, ma'am, absolutely.
Okay, so-
And so the court went through 302A3. The court went through.
So does the case turn on whether or not the comment, or as Brown understood it, what he repeats to a federal agent, which of course would be a crime if he lies, that his understanding is that this large number of guns, as he said, the largest number he had ever sold, never sold that many guns at one time, was for the purpose of resale. That's the purpose, resale, and the resale is going to be out of shops in Ohio and Buffalo. Does the whole case turn on that, whether or not there's minimum contacts, whether or not that satisfies 302A3?
That would certainly be an influential fact. I would think the context.
Why isn't it dispositive? Why is it influential?
Well, because you have to look very, very clearly and specifically at exactly what those words were. And there were.
Let's say it's what Mr. Brown tells a federal agent.
Correct.
They're buying large numbers. I've never sold this many. I want to dash all the T's, dot all my I's. I want to make sure it's fine. And they're buying these to resell out of a store in Ohio. I'm sorry, he called them shops. Out of a shop in Ohio, out of a shop in New York.
Correct. And again,
Assume for one moment that's what's said.
I don't think that even remotely comes close to
Okay,
getting.
so why is that not enough?
Because that clearly, going back through International Shoe, Worldwide Volkswagen, up through Walden, that's speculation and future possibilities that just simply don't meet those tests. Because on twofold.
Let's try my hypothetical.
Okay.
Not the way you're asking us to read the record. Let's just try this hypothetical. Customer comes in and says, I want to buy these 85 guns at one time, I think it's 85 at one time. I'm going to resell them in New York. Here's my ID, they do the criminal background check. Is that enough? Just with respect to the long-arm statute, I'm not asking you about the due process analysis.
Conceivably, that might be, depending on the rest.
Romanet 1, Romanet 2, or both?
Well, those tests go to substantial revenue derived from, and so you still need to look beyond those mere words and get to the facts of what's actually going on.
Mm-hmm.
And so that you can't answer that just based on that mere fact pattern, because there's more to it just under the constitutional analysis.
But if we read the record, as he having said that his understanding was that these were guns to be resold in a New York shop, saying that possibly satisfies 302A3.
Well, if that's what was said, but respectfully, Your Honor, I don't believe that's
Well,
what
it's in the
record-
transcript, right?
Correct, it is. And there were 3 mentions of that, and I think they're critical for purposes of our analysis, because if the test was the word buffalo spoken, we would lose.
Well, it is New York.
Yes, New York. And the word that was used
It
was
wasn't Buffalo, Wyoming, so
Correct.
everybody knows what we were talking about, right?
Exactly, but if that was the test, we would lose, but that's obviously not the constitutional test, and so you have to look at those 3 provisions. And the first conversation is at the record at page 448. All 3 of these are cited extensively. Mr. Brown's relating a conversation that he had with his assistant based on the conversation between the assistant and Mr. Bostic the first time they met. And I have those words here for purposes of the record. They're at page 440.
Right, but I'm referring to the conversation Mr. Brown has, the defendant has, with a federal agent. I'm not talking about his recollection of what someone else remembers or what someone may have said to him. I'm talking about what he remembers, having said his representations to ensure that he was complying with the law to a federal agent.
Yes, ma'am, I understand that. And again, there's a discussion in the record. The first mention of that is at page 450 of the record.
Okay.
Where Mr. Brown is discussing the conversation that he had the first day he met Mr. Bostic, his personal conversation with Bostic in June of 2000. And that language at page 450 of the record is, what did Mr. Bostic say about his plans to open a gun business? And Mr. Brown's answer was, he said his plans were to open up a shop in Columbus, Ohio somewhere. We discussed, as I recall, some of the other gun shops that were around Columbus. He talked about being from Buffalo and wanting, he said he wouldn't mind having a shop in Buffalo also. Said he had been out to several retail stores, seeing how they were laid out, et cetera. And so I agree that the words are on the page at page 458 of the record, but they can't be taken in that vacuum. You have to look at everything. Under a summary judgment motion, it does have to be construed in the light most favorable to the plaintiff, but it also has to be construed in light of the applicable law. And that law, under both the long-arm statute, because it brings in due process and minimum contacts, under both I and the first half of II, which is a twofold test. And that's actually what the appellate court did. After they went through the long-arm statute, they got to the first half of II, and they said, well, this implicates minimum contacts. They went through the full-blown minimum contacts analysis, International Shoe, Worldwide Volkswagen, up through Walden, and they said there aren't any minimum contacts. And then they circled back around, and what the court said was that even under 302A3I, that revenue, if it's not derived from constitutionally permissible contacts, can't be counted. And so the appellate court ruled that there was no jurisdiction under I.
I'm having a hard time. See, we kind of narrowed the issue down before in the discussion with the other judges, and it really comes down to purposeful availment. And it seems that that's where the discussion was heading before. For you to be successful, don't you have to distinguish the analysis in the Burger King case where the court there said you can't avoid jurisdiction just because a defendant did not physically enter the state, and which is seems to be the standard that's being promulgated here. And secondly, you'd have to avoid the analysis in the United States Supreme Court Calder case, also is the Florida libel case, where the question was whether or not something had to be expressly directed at California in the libel action. Can you address those, try and distinguish those for me? Why they don't apply to this case? I mean, even the appellate division put a CF site in for Burger King.
Absolutely, and I would readily admit that the fact that the defendant doesn't physically enter the state, that's not dispositive. It might be a factor, but you have to look at all of the purposeful availment factors. Jurisdiction's designed to protect the defendant. He's supposed to be in charge of that. And that entire line of cases with Burger King and all the others, it goes through. Mere possibility isn't enough. Jurisdiction doesn't travel with the chattel. It can't be the conduct of a third party. It has to be the defendant.
That's a good point. Like, let's say jurisdiction doesn't travel with the chattel. Usually, in that situation, that's a New York car going to Oklahoma and getting a car accident. Like, I guess it was Volkswagen. I can't remember if it was Volkswagen International Shoe, but it's been a long time since law school. But nonetheless, they involve a single instrumentality. This is clearly not a single instrumentality. This is a question of whether or not they entered, this person was conscious of entering the stream of commerce that would culminate in Buffalo, New York. And you have to distinguish those cases. Otherwise, we're establishing a bright line rule that says that that minimum contacts are now something much more than they ever were before in New York State.
And we can distinguish those contacts when we look at the facts of what happened here. Mr. Brown had a federal firearms license that permitted him to only do business in Ohio. It's against the law to do business outside of the state of Ohio. Mm-hmm. Pursuant to the law, he's only allowed to sell handguns to Ohio residents who provide valid government-issued photo ID verifying that Ohio residency. And so when you look at all of that and then the other factors that go along with that, of no advertising, of no targeted telephones, solicitations, marketing, no sales rep.
Counselor, if the facts of this were exactly the same, but Bostic actually had a legal firearms store in Buffalo, would Brown be subject to personal jurisdiction in New York? Would that make any difference?
Not unless the facts are the same, not unless that he purposely availed himself of that and was aware of it and everything else.
Let me ask this, if I may. I know your red light went off with the Chief Judge's permission. Should we factor into this analysis that guns are dangerous instrumentalities, and this is a gun trafficking process, it's an illicit market? Should we factor those into the analysis, and if not, why?
You can't, Your Honor, for a couple of reasons. And one, I would never diminish the incident that occurred here. But the law has to be applied dispassionately, and this and every other case that we have. And the law does not
Well, it's not about passion. It's just the cases that we're talking about are all about a commercial enterprise that's lawful. It's all about, on their face at least, products that are not necessarily dangerous in the way a gun is dangerous. Obviously, if there's a defect, they may very well be dangerous. But using a gun as intended is by itself, right, inherently a dangerous instrumentality. So that's why I'm asking the question.
Well, and so, again, a felon intentionally shooting somebody is clearly dangerous. I would take issue with characterizing a gun as an inherently dangerous instrumentality. It's a physical object.
But there's no question that this was, you don't advertise, well, at least to my knowledge, you don't advertise on the web to say, if you want to buy guns illegally in Buffalo, come to Ohio. People don't do that. I think it's fair to say they don't do that. We're not going to have that kind of proof to establish minimum contacts. What we're going to have is the direct contact that takes place at gun fairs. That's how this market works. You'd agree with that, right?
No, I wouldn't, Your Honor.
So how would illegal, you don't think that this is how illegal guns are brought into, they're illegal in New York, they're legal in Ohio. How are they brought in? They're brought in by entering the stream of commerce. And so to say that the bar is the establishment of a website, we're not selling chocolates here. The nature of the product mandates the nature of the stream of commerce, I guess is my point to you. And so we're kind of stuck with analyzing the facts in those light. in that light, I mean.
And I would submit, Your Honor, a firearm is a legal product lawfully sold like any other, in fact, subject to much higher restrictions of an FBI background check, of only
Of
selling
course,
in Ohio
actually,
to
in point of
Ohio
fact, I have a
residents, et
gun
cetera.
license. So I have a gun license, I'm probably the only one in the court who does. Well, I'm not sure about Judge DiFiore, she might, but I had one. I have my father's guns. My father was a policeman in the city of Buffalo and a police captain in the city of Buffalo. I'm totally familiar with guns and the process by which you obtain them. But I'm not concerned about guns here, actually. I'm concerned about the minimum contact standard, because I say to myself, what if this wasn't a gun? What if it was a child's pajamas that wasn't properly fireproofed? What if it was food that was improperly packaged? And what if it was any number of articles that could be sold and result in harm in my community as a result of the way they entered the stream of marketed stream of commerce and were used. So it's not the guns. I think that's incorrect here. I think it's really the profound legal question is, what's the nature of minimum contacts? What's minimum, I guess, is, in my mind, the profound
Agreed.
question.
And I think that circles right back to where we started, of that line of cases going back through International Shoe and Worldwide Volkswagen, where you look at this issue
You
the
understand
same
my
way.
point, though, is for your argument to sway, I'm only speaking for myself, to sway me, you have to distinguish those cases, and I haven't seen that. That's why I'm asking it.
Well, again, Your Honor, I just, the facts of those cases are so radically different from what we have here. I don't believe it's a matter of the legal propositions that they stand for. When you apply them to what we have in this particular instance, that just simply doesn't rise to the bar, and you have to circle back to that jurisdiction is a concept designed to protect the defendant, not the plaintiff's convenience, and that's why we have to go through this analysis before you can haul somebody into court in a foreign state like this.
Thank you, counsel.
Thank you, judges.
Counsel, respondent described Mr. Brown's business as a local business, and assuming his description is accurate, is that what our New York State legislature intended to capture when it enacted the long-arm jurisdiction?
Well, first of all, Your Honor, it's not exactly local, and there are charts in the briefs that go into out-of-state sales to law enforcement and long guns to people outside of Ohio.
So
But
you
more-
challenge the factual basis?
Yeah, it's not totally local, but most importantly, Your Honor, in Lamarca, if the manufacturer in that case had a license which said you can only sell the product, I'm forgetting what the product was, in Virginia, the facts wouldn't have been, the case would not have turned out any differently, because somebody came to Virginia, bought the product in Virginia, and resold it in New York. And there was personal jurisdiction, and it complied with due process. That's the same thing here.
That was the company's distributor, right? It's a New York distributor. It's more obvious on its face that you are indeed seeking to penetrate the New York market because you've got a New York distributor, right? Unlike this situation where you have someone who's at a gun show, it doesn't matter to him if someone's coming and says, I want to resell it in Jersey, I want to resell it in Massachusetts, right? It's fortuitous, whatever they may say, is the place where they're eventually going to resell it, if they even say that to him.
The question is, did Brown voluntarily assume to supply the New York market? And that's what he did.
Let me
And Your
ask
Honor,
let me ask you this question. Suppose I walk into a little corner grocery store, mom and pop store, and I buy a box of candy bars, and I do this several times, and I tell the owner that I'm doing this because I have this eBay business, and I have a customer in Florida who can't get these candy bars in Florida. So, I do it 2 or 3 times, and then the customer in Florida ends up choking. There's some defect with the candy bar and ends up choking. Is the owner of the mom and pop store subject to Florida jurisdiction on those facts?
I think it would be a factual determination.
Well, on
and
those facts.
And it would be much weaker than our case, but there would be, the argument
Why
would be,
is it weaker if the person selling the candy bars knows that I'm sending them into Florida? Why is that any different from what we have here?
There might be jurisdiction. Here, though, and I think, if Your Honors, here, this question hit the nail on the head, that if Bostic actually had a store in New York and Ohio. And the exact same facts happened, and he said, I'm planning to buy these 85 guns and 182 guns in order to supply those two stores. There would be absolutely no question. There would be personal jurisdiction and due process, and the only difference here is because
Let me ask the same question I asked your adversary about whether or not the fact that it's a dangerous instrumentality and we have an illicit market should be factors for us to consider, and again, if so, how should we do that?
I think it should be in this sense. Not for this case. You don't need it for this case, because in this case, you have the testimony of plan, the word planned, and the defendant has to prove that as a matter of law, the statement, I plan to open these stores and sell these guns in those stores, as a matter of law, that's not purposeful availment. And I don't know how you get there on the summary judgment standard, but there are going to be more difficult cases, which you could face, Your Honors, where you have gun traffickers who don't open their mouths and don't say, I'm going to resell. And what about the gun trafficker who says, who buys 100 AK-47s every week from the same Ohio gun dealer, and the Ohio gun dealer gets notices that those guns are being traced by New York law enforcement, but he never asks a question, the person never says they're going to New York.
Did Brown get notices about where any, I'm not just talking about the guns Bostic purchased, any of those other sales? I know you had charts in your briefs.
There were some traces, but I can't say that any of them were before this sale. But the point is that if Your Honors shut the door to New York authority in a case where there's sworn testimony from the defendant that he was told of the plan to resell these products, extraordinary testimony. I'm not aware of any due process case in New York or in the Supreme Court where there's sworn testimony about the defendant's purposeful availment of that particular sale. But if you shut the door in this case, then you have completely shut the door to the case with the more crafty gun trafficker who does not say where he's going to resell the guns, yet the dealer should know he's supplying the New York crime market.
But the plaintiff still has a place where they can sue. The plaintiff can always go to Ohio in this particular case.
That's correct, Your Honor.
This is a question of the plaintiff being able to select the New York.
Your Honor, but also, of course, the defendant's, the burden on the defendant is the primary factor, according to Supreme Court precedent. It's not the only factor. New York's interest is also a relevant factor. The plaintiff's interest is a relevant factor. And by the way, in this case, there is absolutely no burden on the defendant because Mr. Brown is going to be in court in Buffalo in this case on behalf of MKS, his other company, which is another defendant, which has submitted to jurisdiction. So there is, as a factual matter, there is zero burden on the defendant in this case.
Would you allow me one more question? So I want to go back to the statute for a second and give you a hypothetical. If Mr. Bostic, instead of saying Buffalo, had said Miami, and the guns nevertheless wound up in Buffalo, is the statute satisfied, particularly 3(2)?
I think that is it's a much weaker case on that prong. There's no question about it. I mean, and the facts that you've given me, there may not be a basis to know that the guns were going to New York. There may be external facts.
Assume that there was no basis to know they were going to New York.
Yes, but you may get jurisdiction under the other prong. But I think that's correct, and that distinguishes, of course, this case and highlights the strength of this record.
But let's say, if I might, Chief, let's say under Judge Wilson's hypothetical, that's the case, and I'm sorry if this was your hypothetical, but these guns are going to Miami and they wound up being sold in New York. Do you get jurisdiction under 302A1, 3 Romanet 1?
I'm sorry.
So same hypothetical, and I hope this is a little bit different. Buyer says, I'm going to sell these guns in Florida. In fact, they sell the guns in Buffalo. Is that your hypothetical?
That's it.
Okay, so that would be a pure sale in New York without any foreknowledge. So that is, you think, is a closer case?
Well, in that case, you would derive, the question is, have you derived substantial revenue from goods used? And if the amount of the sale is substantial revenue, then you comport with 3.1.
And doesn't that suggest there needs to be some type of volition or knowledge element in that portion of the statute? Because in that hypothetical, how could that comport with due process? I believe I'm selling these guns to you. I believe you're taking them to Miami. You've told me that. You wind up diverting them to sell in New York. I have no idea you're going to do that. And then how could we possibly exercise jurisdiction under 302A Romanet 1?
That would be a due process argument for a much tougher case. But again, you have the fact
You have to read the statute to comply with the due process.
Well, for this case, we need to read the statute as applied in this case. And as applied here, we have the testimony of planned to open a store. And I would say that is all Your Honors should look at. The other testimony, page 448, page 450, the court cannot, on summary judgment, the appellate division should not have picked and chosen which of the inconsistent statements of Brown the court chose to rely on. That is simply not permitted on summary judgment. And nor can one read the word planned to open a store in the context of someone who is understood to be buying inventory for that store to resell, making all inferences in our favor. I don't see how that can be read other than purposeful availment of the New York market, a voluntary choice by Mr. Brown, which he didn't have to make. He could have said, I'm not going to sell these guns because I don't want anything to do with New York. That's what he should have done. That's what the other dealer did. He didn't. He said, I'm happy to take your cash and bear the risk of supplying the New York market, which is what he did.
Thank you, counsel.
Thank you, Your Honors.